Hello, Sir Richard. This is Reem. I would like to begin by reading out a short statement, which in return I will ask you and the parties to confirm is correct. I hope that is okay.
Certainly, go ahead.
This hearing is in the matter TCD 002-2020 before Justice Sir Richard Field and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Pinsent Masons LLP. Lead counsel is Mr. Nick Tolley. The defendant is represented by Mr. Gopinath Kodoth as a litigant in person.
Well, thank you very much. I confirm everything you said, and I'll ask counsel to say the same.
This is Nick Tolley for the claimant. I confirm.
Sir, I'm Gopinath Kodoth, sir, for the defendant. I'm the defendant in person.
I thank you very much. Now, Mr. Tolley, you appear for the claimant. Do I understand correctly that the principal matter to be dealt with during this PTR is the defendant's application to serve late a fresh witness list, having not served the list, I think by it was sometime in September of last year that the deadline was set for the service of witness list. Is that correct?
Yes, it was originally 6th September 2020 was the deadline, which we say was missed.
Right.
Sir Richard,
Well, now,
I'm
yes?
sorry to interrupt. Just for the record, the matter is TCD 002 of 2019.
Yes, thank you. That's fine for the record. So, Mr. Kodoth.
Yes, sir.
This is your application.
Yeah.
And I've read your application notice, and I've read the response that's come from Pinsent Masons on behalf of the claimant.
Yes.
Would you please now proceed to make your application? And in the course of doing so, please explain why it is that at this very, very late stage, we're in a position where the defendant is having to apply to retrospectively to serve a witness list, having missed the deadline that was set on, I think, the 6th of September of last year. So over to you, please.
Sir, I have filed an application for the witness list with a condemnation application, with a condemnation for the delay. I am leaving the matter to your lordship to decide on the matter.
Yes. Well, would you please explain?
Yeah.
What is the explanation for this very, very long delay?
Yeah, it was in fact, it was happened because of the oversight, Your Honor. Oversight, Your Lordship, by oversight. Because that is why we filed an application for condone the delay in filing that witness list, sir.
But as I understand it, at the CMC order required a Rule 23, I think it is, application formally to be made. Now, why wasn't that done?
That is because, I have been dealing with this DFC code for the first time, Your Honor, Your Lordship, first time, because I am, not very much familiar with this procedure of DFC codes. So I was not very much aware of the procedure, even though I had gone through it. I'm very much aware, so can be treated as an oversight from our part, and I humbly request to accept our application for the witness list, Your Lordship.
Well, I understand the witnesses you name.
Yeah.
Are Ahmed Ghali.
Yeah.
And Manoj
Madhavan. Yes, sir.
Now, are they? What is their connection to the case? How are they? Wait a moment. Wait a moment, please. how are they able to give relevant evidence in this dispute? Just explain that briefly, please.
Yes, Mr. Gali is the expert, appointed in this matter, he was appointed as advised by the small claim tribunal to file an expert report on the matter, on the dispute. So he filed an expert report. So I cited him as a witness number 1. And Manoj Madhavan is an employee of our company, is an engineer, and who dealt with the matter in the course of the project. So I cited both our witness for my part.
Now,
is claim of the claimant.
Just leave the experts report. Is that a report that was lost for a small claims matter? What's the answer to that question?
Question to myself, Your Lordship, to myself?
Yes, I was asking you. Your expert witness, Mr. Gali, he's written a report, has he?
Yeah.
And was that report served before this matter moved from the Small Claims Tribunal into the TCD?
Yes, sir.
Well, what was it? Was it served during small claims, or was it served once it had gone into
small
the
claim tribunal? A small claim tribunal. It was filed before the small claim tribunal, sir. Thereafter, it was referred to. In fact, it was referred to court of first instance.
So right, and so the claimants have had that report for some time, have they?
Yeah. Claimant filed objection against the report. Meantime, small claim tribunal has not decided the matter. Rather, it referred to this court of first instance. Meantime, claimant approached TCD court, TCD tribunal for the further proceedings. Instead of approaching court of first instance, claimant went to TCD.
Yes, I see.
Yes, sir.
Now, Mr. Madhavan, he's an employee, and you have a signed witness statement from him, do you? Mr. Kodoth?
Yes, sir.
You have a signed witness statement from Mr. Manoj Madhavan, do you?
Yeah. Manoj Madhavan, yeah, an employee of our company.
Yes.
Yeah.
And have you served that on the claimant's lawyers?
No, I filed an application, in the court with a copy to the CC2 copy to claimant lawyer, sir.
Well, did you make part of your application, part of the material that you were to rely on in making the application, did it include a copy of this man's signed witness statement?
Yeah, not signed witness statement. It's an application only, not signed one. It's an application for my part only, sir. Not signed one.
Not a signed witness.
One. I cited them as my witness from our part, not signed by them.
My lord, if I may assist, there was no witness statement signed or unsigned served with the application.
Right. Now, Mr. Kodoth.
Yes, sir.
What else do you have to say in support of your application, please?
I humbly request your lordship, please accept my application for the witnesses.
Very well. Now I'm going to hear Mr. Tolley in reply, and you will have an opportunity to respond. Now, Mr. Tolley, what are your submissions?
Thank you, my lord. May it please the court. The claimant's primary submission is that the defendant has continued to fail to comply with the court's orders, and it shouldn't be granted permission at this late stage for the witness evidence it seeks to rely on. They've missed a number of deadlines, and at the previous CMC, it was, I completely concede that Mr. Coe is a litigant in person, but the registrar went to great lengths to make clear the necessary procedural steps to be taken in order for permission to be granted for this retrospective application, as it then was, and it is again at this time, to submit the names of the witnesses late. And the registrar went so far after the CMC as to send a link to the relevant DIFC pages explaining how a Part 23 application was to be made. And at the CMC, the registrar...
Sorry to interrupt. When was that CMC? When did the registrar deal with it?
It was on the 17th of February.
Oh yes, that's right. I remember the date. And was that registrar Noor Hanidi?
Yes, my lord.
Yes.
Yes.
And she sent, you say she sent a link to Mr. Kodoth to assist him in filing a proper application in accordance with the rules.
Well, so that I'm absolutely clear, she said at the hearing, she asked if he understood what he needed to do, and she explained it would be a Part 23 application, and Mr. Kodoth said that he would make such an application. And then following the CMC, not Miss Noor Hindley, but another member of the DIFC court registry sent a link to the, because Mr. Kodoth wrote asking how he was to do it, and they replied and sent a link to the relevant information.
Can you give me some idea of when that link would have been sent?
Yeah, I'd have to check, my lord, but it was around about the 3rd of March from memory.
Yeah. Yes, do go on.
My lord, I was just addressing the court on the fact that the original deadline was in September. Then there were deadlines set by the CMC, as it were. There was attendance at that CMC, and there was still no witness evidence, no names of witnesses tendered. The point was raised, and then, as I've already said, there was follow-up, and yet still nothing further came through. But there are a couple of other fundamental points that I'd like to get across. One is that whether or not the court now accepts that any valid application has been made absent a Part 23 application, and the claimant's position would be that merely sending the names through to the e-portal isn't sufficient. The second point is, at the CMC itself, Mr. Kodoth has asked very clearly a number of times and confirmed that there would be no lay witness evidence from their side. So I'd like to address the court separately on the issue of lay evidence and expert evidence. So on the lay evidence side, we say that there was confirmation that none would be provided, and therefore Mr. Kodoth shouldn't be allowed to reverse out of that position at this stage. And in the absence of any proper formal application, and with that undertaking having been given, he should not be allowed at this late stage, which could prejudice the trial date, to be put in any further lay witness evidence.
Just remind me, what undertaking are you referring to?
At the CMC, he was asked what evidence he would like to rely on, and he said he'd like to rely on the expert evidence that was tendered in the small claims tribunal. The registrar explained to him that they would have to, essentially, that things have started over by it being moved to the TCD, and he would have to put in any application and any names for his witness evidence to the TCD. And I asked the question expressly, and the registrar put the question expressly to Mr. Kodoth, whether he intended to rely on any lay witness evidence, and his answer to that question was no. And he expressly confirmed that it was only going to relate to the expert. So we were quite surprised when later came through a name with more than one, came through to the e-portal, an application or purported application with more than one name on it. So perhaps undertaking is too legalistic a term. It was a confirmation to a question expressly asked as to whether he would be applying for any lay witness evidence, and he said no.
Yes, I see. Now the expert report that was served during the small claims period you've had, you're relying, I think, on expert evidence. Is that correct?
We're not, my lord.
You're not?
We're not. But we have reserved our permission. Sorry, we should say we reserved our position that in the event that this application is successful and expert witness evidence is allowed on behalf of the defendant, then the claimant should, of course, have a chance to reconsider whether it wishes to rely. But part of the reason that we're not relying is that our understanding was that the defendant was not relying on any expert evidence.
Is the expert report, is the contents of that relatively fresh in your mind, Mr. Tolley?
My lord, it's not. But I know, because I read it many months ago, but it isn't. And this is something which I'd like to clarify in the event that any permission is given. It's not an expert report in the ordinary sense that one would expect to see. And this is why in our response to the application, we reserved our position to comment on the eligibility of the alleged expert. It's a report which we would say is where the author is acting as an advocate in the defendant's case, and it wouldn't satisfy the requirements of independence that one would normally expect to see. And we haven't yet made any submissions. I haven't formulated my own views on that because I didn't think that was the purpose of the responding to the application and the pre-trial review today. But what we say is that whilst our first submission is that yes, it may have been before the Small Claims Tribunal, but it's not been before this court, and permission should have been applied for, which it hasn't. And our second submission is that we reserve our position, but once we've had sight of that report again, or refreshed our memories if we access the small claims file, we might be able to make submissions that it isn't actually capable of satisfying the rules set out in the JFC court rules for independence and integrity and the other points relating to an expert report.
Yes, I see. Now, most unfortunately, the trial date that was identified, I think in a CMC order, now cannot be effective. I think it was due to be tried on the 21st of April. Is that right?
Yes, my lord. Now,
what steps are being taken to find an alternative date as soon as possible, alternative date in place of the 21st of April? Are you able to help me with that?
Yes, my lord, I can assist. The claimant anticipated this being a difficulty and wrote to the registry, but the registry, I'm sure they were aiming to be as helpful as possible, but they suggested that we discuss it with you at this hearing today. And our submission would be that whatever trial date is set, we would need to work back for the obvious points about
That's
chronology.
Right. You'd have to work back.
Yeah.
Well, I could take this trial sometime shortly after the 10th of May. I'm not in a position to give an absolutely clear date. The diary is something of a work in progress, but around. I'm just going to look at my calendar. If you'll bear with me just for a moment. Sometime in the week beginning the 10th of May, although of course in Dubai, the week would be beginning on the 9th of May, Sunday to Sunday. I think it is pretty likely that I could. It's a one-day trial, isn't it?
Yes, my lord.
Yes, Lord.
It's pretty likely that we'll be able to fix it in that within that week. Which is about 5 or 6 weeks forward. Now, just make the assumption, it's not set in stone, make the assumption we can have the trial in the week beginning the 10th of, the 9th or the 10th of May. If this if it's a big if, I'm very undecided on the question. If di bene esse, the expert report would be permitted, subject to any objections to be made to its nature, that such objections could be dealt with on paper, could they not, between now and the week beginning around the 10th of May? It wouldn't take you long, in other words. It wouldn't take you long. You've got this report in your file somewhere. It wouldn't take you very long to have a look at it and to decide whether you're going to object to it as not being proper expert evidence, and whether or not you would need to file expert evidence in response.
My Lord, that's correct. My only concern would be if it's the latter course, it may be a bit tight for us to then obtain an expert report in response. I have no issue with the amount of time required for us to review the report the defendant wishes to rely on, or to put in submissions objecting if we're so minded to do. But
one of the difficulties is, Mr. Kodoff, you can hear me. One of the difficulties I find myself in is that you have not brought to the court's attention as part of your application for this expert evidence the report of Mr. Ghali that was served during the small claims phase. And so I have absolutely no idea as to what the likely repercussions would be if I were minded to give permission for it. Now, you are a qualified lawyer, as I understand it. Is that correct, Mr. Kodoff?
Yeah, because my lord, I'm not aware of the procedure of the DFC code. This is the first in TCD. This is the first time I'm attending for a trial, sir. For a trial.
Well,
my lord, yeah.
I understand that, but is it not a matter of common sense that if you're making an application to be allowed to adduce an expert report, you show the judge the contents of the expert report so that he can make his mind up against the background of the report itself?
Yeah.
Now, why have you not done that?
So, which is why, sir, my lord, I have filed an application for condonation of delay, because it was a mistake from my part, because there is oversight was happened because of oversight. So there's an application filed for condonation of delay from my part, and it was accepted by the
Is it not just a matter of common sense that here you are, this PTR has been in the wings for some time. It's finally decided that it should be heard today. You made an application, but not a Part 23 application for permission to adduce this report. That application would have to be dealt with either by the registrar or by a CFI judge, and you have not put before the court the report itself so that the court can make a sensible decision whether to permit this evidence to come in or not.
Yeah. So I was totally aware of the complex complex procedure of this TCD code or DFC code, Your Lordship. So it was produced in the court of small claim tribunal, and I was under the impression that all the documents which was produced before the small claim will be taken up with the TCD also. I was under the impression that.
Well, you don't have this report with you at the moment, do you?
Pardon, sir? Pardon, Your Lordship?
You do not have this expert report with
Yeah.
you at the moment, do you?
Yeah, we have.
You do.
Yeah.
And how many pages is it?
Pardon your lordship. Pardon your lordship.
How many pages? How many pages is it?
Wait, just a minute. Yes, sir. It contains 1, 2, 3, 4. It contains 10 pages, your lordship. Your lordship, it contains 10 pages report.
Well, I think what I'm going to do is this. This may or may not have some cost consequences for the defendant. I am not going to permit the service of the evidence of Mr. Manoj Madhavan. The court was told in no uncertain terms that no lay evidence was going to be, and the court cannot be involved in the application in respect of lay evidence. As to the expert evidence, I'm going to direct that this report be sent to me forthwith, and Mr. Tolley, are you available at the same time tomorrow, 4 o'clock, for an adjourned hearing on this question of the expert report?
My lord, it's a non-working day in the UAE, but I'm more than happy to make myself available at 4 p.m. tomorrow.
Oh, of course it is. It's a non-working day. Friday. It's a Friday. No, I don't think the court can. And then it would go over to Sunday. Well, what about Sunday, Mr. Tolley? Could you do 4 o'clock on Sunday?
My lord, I have a jurisdiction objection hearing before a 3-member tribunal starting at 2 p.m. on Sunday afternoon, but I could possibly do Monday.
Well, what about Monday?
If you just bear with me for 1 moment. I'm available at this time on Monday afternoon, on the 12th, my lord.
Could you pencil that in, please?
Yes.
Now, Mr. Kodoff.
Yes, sir. Yes, your lordship.
You must understand very clearly.
Yes, sir. Yes, your lordship.
The fact that I'm prepared to look at this report is not give rise to no inference or presumption that I'm going to permit it to come in.
Yeah.
I'm just trying to be as fair as possible. And so I wish to have a look at the report, and
Yes,
I want to hear Mr. Tolley's comments on the report, which can be done on Monday at 4 p.m. Now you must immediately after the end of this adjourned hearing.
Yes, sir.
You must send this report to the DIFC registry for onward transmission to myself.
Yes,
Do you understand?
Yes, my lordship. Yeah, yes, my lordship.
And in the meantime, between now and Monday, I will try to establish a firm adjourned trial date. Mr. Tolley, that week beginning around about the 10th of May, would you be able to deal with the trial on one of those days in that week? Does your diary permit that?
Yes, it does, my lord.
Very well. Well, then we will adjourn, and final decision will be made in this matter on Monday. I'm going to get offline, but I would like Alia, please, to telephone me, and I'll speak to her about a trial date. Are there any observations either side wish to make before we adjourn?
Your Lordship, may I clarify them? Your Lordship, may I clarify that this report I should send to DFC registry, right,
Yeah.
sir? Right? Yeah.
The expert report must be sent forthwith to the
DFC registry. Okay.
Yeah.
Yes, Your Lordship.
All right.
My Lord, there was one further point, if I may.
Yes, of course.
Just to use this time as best as possible, the pre-trial review itself, I had a look at the various forms completed by each party, and there was just one issue that I think needs the remote hearing and remote witness link. Again, you might be able to discuss this with the registry, but from the claimant's side, we have one witness, a lay witness called Dominic Sharman, and he would like to attend from the UK remotely.
Yes.
Yes. And obviously we have everybody that's on the call today, I would anticipate, but I'll just leave it there. So it's the need for a remote witness link.
Now, I can tell you now that I would permit your lay witness to give his evidence remotely. How would that be done? Would he be in an office somewhere, or would that be from his own home, or what?
I'm of course aware of what my lordship's driving at. If it's necessary, we could arrange perhaps for him to travel to the nearest office of Vincent Mason's. I'd have to find out his home address and where that would be. But I'm sure his primary preference, if the court had no objection, would be for him to attend from home in the usual fashion.
He can attend from home, and he must be entirely on his own. No one else must be in the room. And there's an e-bundle, is there, for this trial? Or
hasn't been prepared, but I'm sure there will be come a week or two before trial.
Well, he's going to have to be trained how to use the e-bundle so that we don't keep stumbling.
He can do that.
Well, on the basis that he can be fully prepared to use the e-bundle, if it still remains a very big if. Well, actually, it's not an if, because this is just lay evidence, isn't it? At the trial, your witness, what's his name?
Mr. Dominic Sharman.
Dominic Sharman can give his evidence from home. But I'm relying on Vincent Mason in conjunction with the registry to ensure that we have a system, whichever it is, if it's the homegrown one or whether it's a Microsoft Teams or what, which is going to stand up and work, and the witness will be familiar with using the e-bundle. All right?
Understood.
Any other PTR type matters to deal with now?
Nothing from the claimant.
Nothing, Lordship.
Nothing from you. Very well, we shall resume on Monday.
Yeah.
By Dubai. Thank you very much.
Sorry to interrupt, sir. I'll ask Alia to call you right away.
Yes, I'm going to come out of this hearing, and Alia can call me on the number she has. Thank you very much.
Thank you.
Goodbye.
Goodbye.
Thank you, Your Lordship. Okay. Adila, കഴിഞ്ഞു